Good afternoon. Today, the Faculty of Law of the Catholic University of Lille is welcoming Mr. Jauregui from the Court of Justice of the European Union to raise a topic relating to the reference for preliminary ruling before the court. So thank you, Mr. Jauregui, to be here with us today. I will ask you first to explain a bit your work at the court and what are your main tasks and with which judge you work.
So I'm référendaire, a law clerk at the Court of Justice. I'm working in the cabinet of a judge. It's the Cypriot judge. And my main task is to treat the cases brought before the court and which my judge is responsible with, and treat them with him and write the decisions of the court to resolve the cases before the court. Yes.
Can you explain just briefly how works the court inside? And
the court works, distribute its tasks in different chambers. We have now, in between the 28 judges of the Court of Justice, 5 chambers of 5 judges each chamber, and mainly most of the cases are dealt in those formations of 5 judges. Some big cases are dealt in the Grande Chambre, so that means 15 judges formation, and some less important cases are dealt in the formation of 3 judges.
As you say before, this court is mostly working in French, even if officially other languages are used, but the working language is French.
Yes,
yeah?
the working language is French and is still being French. But we need to know that every piece of legislation or the decisions of the court are translated in every official language of the European Union, and that proceedings may be brought in all these official languages. Then they will be translated into French in order for the judges and the référendaires to resolve and treat the cases in French. So the original decision is always in French.
Thank you.
Thank you very much for being with us today.
Thank you.
We had the chance to listen to you speaking within the European Institutions course with Mrs. Silvia Bartolini in front of the European LLB students and the International European LLM students on the question of the reference for a preliminary ruling in front of the Court of Justice of the European Union. Could you please explain to us what is a preliminary ruling and what are the major issues around this legal proceedings, please?
So the preliminary ruling is the cornerstone of the judicial system of the European Union. As I said in the presentation before, almost 2/3 of the cases brought before the Court of Justice are preliminary rulings references. Through the preliminary ruling reference, the court permits the uniform interpretation of EU law, and so the citizens have equal rights and can invoke these rights everywhere in the European Union. So the preliminary ruling main objective is to attain the uniform interpretation and then application through the national courts of the EU law, and this procedure has been very successful in permitting the citizens to invoke their rights in front of national courts and then to the Court of Justice.
Thank you. And what are the main issues around it today? Why is it? Why are we talking a lot about the references, for example, with the recent case law of the European Union?
Well, it's always very because of this system of decentralized judicial protection of rights, being first the national court has to make a question to the Court of Justice. There are always matters of very sensitive matters which the court needs to deal with. But I think in general the court's approach always towards uniform application and interpretation of law and the protection of the rights of citizens is always prevailing the decisions of the Court of Justice.
Mm-hmm. Let's take a precise example, a precise case that was delivered by the court in the last year, the last years. The Shames case, for example, which was dealing with the Facebook account of the individuals and the fight for the protection of personal data. Could you maybe come back on the main issues of this case? And
well, there is a very interesting thing involving that case, because we saw that an Austrian citizen, Mr. Schrems, went to the Irish courts in Ireland to ask that the United States, or a third country outside the Union, was not protecting sufficiently its rights to its data. The difficulty of that case brought from the Irish court to the Court of Justice was that the court was facing to see or control what was happening in a third country outside the EU. The court had some facts brought by the Commission and other parties in which they were clearly stated that there was a problem of infringement of personal data of the citizens of the European Union made by Facebook, because Facebook had the obligation under American law to give all the data that they had or they were giving from the European citizen, and they went to the server in California in the States. And so they had the obligation to deliver this data to the national authorities of the states without actually any reason to give this data. So there the court made a very important decision towards the protection of the rights of the
and so
citizens.
this is the first time that the court, because then that happened in other cases, that invalidated a decision that based an agreement, international agreement between the European Union and the US. So yeah, it is showing the importance of the reference for preliminary ruling before the court, because the court is controlling the validity of any EU law involvement, and it gave a very important, very high importance to the court.
And then that's why this tool has been widely used by the citizens to make their rights protected in the European Union.
Okay. Mr. Olaguibel, thank you very much to be here today. We're very pleased to have you in our faculty. I thank also Ms. Silvia Bartolini, who made the contact. And this is done for this presentation. Thank you very much to follow us online. And we have very soon other conferences and events, so you're very welcome. Thank you.
Thank you.